Hello, welcome to the lecture on Chapter 4 for your Employment Law class. In Chapter 4, we're going to talk about the legal construction of the employment environment. So, the purpose of this chapter is going to be addressing situations during the establishment of the employment relationship that might bring up legal issues. The chapter is first going to go through, the recruitment procedure and highlights regulations that apply to that area of applicants and recruiting potential employees. And then we're going to talk about preferential treatment, although this topic is discussed further on in the book. But then we're also going to kind of touch on gathering of information through the application interview process and what that looks like and how it's regulated. So let's look at your learning objectives for this chapter. So in this chapter, you're going to explain why employers might be concerned about ensuring protections for equal opportunity during recruitment in particular. How the recruitment environment is regulated. We're talking about statutes and common law that have come through the court system. The employer's opportunities during the information gathering process to learn as much as possible about hiring the most effective workers they can, and explaining how the employer might be liable under the theory of negligent hiring. Identifying circumstances under which an employer may be responsible for an employee's compelled self-publication and thus liable for defamation, explaining the difference between testing for eligibility and testing for ineligibility, what those are, what the different examples are of each, and key benefits of performance appraisal structures, as well as their area of potential pitfalls. So first, let's look at the evolution of the employment relationship. Okay, so there's this evolution of the employment relationship, starting with recruitment and sourcing potential applicants, hiring, evaluating who you're going to hire, testing for promotions, discipline, termination. That's kind of this timeline that we go through in the employment relationship. And it's important to recognize that, personal prejudice and bias often enter into the recruitment process. So it's critical to be conscious of one's own bias as we look at and discuss these issues, in the course, throughout this chapter and throughout the whole course. It's important to kind of think about, those things as you consider, how appropriately it is to respond in certain situations, in certain contexts. The people that work in a business, it's human resources, like the actual humans that work there, are among the most valuable assets that any company has. So consequently, it's important to take a lot of care in that selection process of who these human resources are within a business. The law permits employers a lot of leeway in choosing and managing its employees. Basically, the restrictions on the employment relationship are the laws that protect certain groups from employment discrimination, because history has demonstrated that a need exists for that kind of protection. But the employment relationship usually begins at this stage of recruitment. There's a lot of different techniques to locate appropriate applicants for a job. Targeting recruitment and selection has been found to be the most effective way to reduce employment discrimination charges in the employment relationship. So it's important to remember, this evolution as we think about the employment relationship. There's a few limitations about the discretion that people can use. There's certain choices, that are outlawed because they can't be based on certain factors. But these exceptions to at-will employment are captured with other policies that override employer interests, otherwise unfair to workers. This evolution of the employer relationship, identifying duties and pitfalls when management is careless, it raises the risk of negative consequences and potential problems in recruitment. So the first step, of course, in this employment relationship being recruitment. Unfortunately, recruitment seems to be a step that is particularly susceptible to claims of discrimination experienced in this phase. Of course, the federal law regulates recruitment of employees in this, hiring process and finding appropriate employees. And it's important to recognize that, there's a lot of different statutes that apply to recruitment, and it's regulated by statutes and by common law. And so The EEOC has offered important guidance on how these statutes apply to recruitment, especially guidance on disability-related inquiries of applicants, as well as employees that fall under the Americans with Disabilities Act. The employer needs to provide reasonable accommodations to a qualified applicant that has a disability, even if it believes it would be unable to provide this individual with a reasonable accommodation on the job if they were eventually hired. It's a different scenario. So we're looking at this evolution of different phases of employment relationship separately. And then it's important to note that states have similar laws that extend to applicant protections. So information gathering and selection. Once the employer has recruited a group of applicants, the next step is for the employer to balance some additional information about the applicant with the needs of the company, along with any negative information on the candidate discovered during the course of information gathering. So in the application phase, the hiring process usually begins with some kind of application for employment. This is a source of information for screening out applicants, to figure out who's qualified for the job, who meets these job requirements. But there's a bias risk in unmanaged systems of review. So there are prohibited questions that can't be asked regarding disabilities, specific health risks, workers' compensation history, that are in violation of the Americans with Disabilities Act. Questions regarding age, sex, religion, marital status, nationality, ethnicity are not prohibited by federal statute, but they're generally going to be considered off limits. The areas of inquiry that are most often violated are going to include education, where not business justified, or where questions relate to maybe religious affiliation of a school or something like that, arrest records, physical disabilities, and age. While most applicants are used to filling in the response to a question regarding gender on an application, an employer actually has no right to that knowledge unless gender is a bona fide occupational qualification. Bias in recruitment can also be seen in what some workplaces call cultural fit, a concept demonstrated when recruiters describe their ideal employee as someone they would go to lunch with. This practice of preferring people that are like unto ourselves, whether it's because they look like us, they sound like us, they share similar backgrounds or experiences, etc., prevents, avoiding an unconscious bias that might exist. So the next step in the process is very likely the interview phase. Risks are similar to the initial application process. It's important that training, is there so that the proper interview is conducted. There's 4 areas of potential problems in connection with the interview. And so these 4 areas are, number 1, the employer must ensure that the interview procedures don't discourage women, minorities, other protected groups, from continuing in the process. Number 2, employers should be aware that all white or all male interviewers or interviewers who are not well trained may subject the employer to potential liability if the team showing maybe potential bias or appearing to have bias. Number 3, training of interviewers for sensitivity to bias is really important in potential questioning because it's crucial to avoid biased questions, gender-based remarks, unbalanced interviews, etc., stuff like that. And number 4, the evaluation of the applicant subsequent to the interview should follow a consistent and evaluative process rather than reflect arbitrary and subjective opinions. We want to standardize the process so we have objective selection criteria as best we can. So once an applicant has successfully completed the interview process, the next step for an employer is to check the applicant's background and references. A check is crucial to verify the information given that the candidate offers in the application interview. It's important as well to ensure there's no information that, if discovered, would disqualify the applicant from employment or could subject other employees, clients, or customers to a dangerous situation. That type of information could also subject the employer to a claim of negligent hiring. For these reasons, employers may verify not only education and experience, but also driving records, credit standing, refusals of bonds, exclusion from government programs. An employer is liable for negligent hiring where an employee causes harm that could have been prevented if the employer had conducted a reasonable and responsible background check on the employee. In other words, when an employer knew or should have known the worker was not fit for the job, the person injured may claim that the negligence of the employer placed the employee in a position where harm could result, and therefore the employer contributed to that harm. One way for background checks is get, permission from the potential employer to prevent these stumbling blocks. Request the applicant sign a statement on the application form which states that former employers are released from liability for offering references on his or her behalf. Use caution with online sources for background checks. While they might be useful for valuable information on a prospective employee, if they use some information like age, race, marital status, other defining features of potentially protected classes to screen job candidates, it could serve as evidence for the grounds of a discrimination lawsuit. Certain information is just not available to employers and is instead protected by state law. So, for example, some states might protect the disclosure of the type of information of someone's prior criminal record or certain convictions, or things like that. So an employer can be subject to a claim of invasion of privacy if they are asking for information that they're not entitled to have. This exhibit outlines the grounds for establishing a negligent hiring claim. So the plaintiff has to show the existence, of that relationship, employer-employee, the incompetence or inappropriateness for the position assumed, the employer's actual or constructive knowledge of such incompetence or inappropriateness, or the employer's ability, the employee's act or omission caused the plaintiff's injuries, that the employer's negligence in hiring or retaining the employee was the proximate cause of injuries. So like on investigation, the employer could have discovered the relevant information and prevented the incident from occurring. And then if you look at Exhibit 4.8, those are outlining employer strategies, for reference checks. Employers could be liable for negligent misrepresentation made in employee references. There's no duty to provide, but it's important to provide training or policies about how employers are going to handle that kind of stuff. Alternatively, again, seeking release of that claim in an employment application in writing could help. And in certain situations, you might have compelled self-publication. And so compelled self-publication is going to occur when an ex-employee is forced to repeat the reason for their termination and therefore might have a basis for claim for defamation. When the reason for their termination is allegedly defamatory, then courts have held that self-publication can satisfy the prima facie requirements of defamation since the employee was compelled to publish the defamatory statement to a third person, this potential new employer. And since it was foreseeable that to the employer that the employee would have to repeat this basis for termination. Some courts recognize the responsibility of employers in certain industries to appropriately train their employees when third parties might rely on that training, such as in the medical environment. Negligent supervision exists when an employer fails to adequately oversee the activities of an employee who threatens violent conduct. So how does the employer protect itself? Well, we have the timeline right here during the interview process, before a position is offered, and after the candidate is hired. And these are some good tips for how, more management tips on how to protect an employer from this potential liability that we just went over on these other slides. Internal documentation of someone who was not hired is not necessarily legally required, but sometimes is recommended as useful in that demonstrating the hiring process. It's helpful to record things when they're fresh, and because memories fade and people can be confused about the events or get other candidates mixed up. But it also helps provide statistical data to monitor self-monitoring of your own policies or to defend a policy in litigation. And so management tips, when recruiting and sourcing potential recruits, casting a wide net, monitoring for bias, being really careful that the interviewer statements, don't mislead interviews, promise things they shouldn't be promising, that kind of stuff. Analyzing applications for accuracy, making sure they're neutral on their face, and also looking at the candidate pools and looking at the statistics, being careful with, the sourcing situations, training interviewers on good sound policy, and considering maybe standardized questions for interviews and evaluations to prevent problems in the interview process. Background checks, they're important to gain information, but make sure that you're acting on properly acquired information and not information that is not supposed to be considered. And then look at the references policy. What is the benefit of getting references? What are the risks and burdens? Like, how can people be trained to appropriately use that information or collect that information? Or what kind of policies do you want people to have in place before seeking those references? So beyond recruitment and information gathering, then another phase of this process, the third step beyond this, is maybe the particular information that might tell an employer if this is the right worker to satisfy the job's essential requirements. So certain kinds of testing might be important to kind of identify who those potential employees are. While pre-employment testing can help locate those ideal candidates, it also could land the employer with some problems and might cause them to go to court. So pre-employment testing is where we'll start, and that's what takes place before hiring. Sometimes it can take place after hiring, but it's going to be before employment in connection with certain situations. But, finding the best person who's eligible for this position or ineligibility test might ensure an individual is free from something that would prevent them from performing the job's function. So those are two different types of tests. And of course, it's important to consider individual privacy rights. Courts are going to do kind of a balancing test when someone's challenging something as a violation of the privacy to decide if this testing, how appropriate it is in connection to the functions of the job and that balance between an individual's privacy protections and the need to know that information. So this is kind of an illustration of that balancing test that a court would apply. So again, eligibility testing is a test to ensure that someone has the potential, is capable and qualified to perform the requirements of that position. Tests for ineligibility, on the other hand, are for disqualifying factors, like drug, alcohol testing, potentially, that kind of thing. Eligibility tests, to be valid, they need to justify that test by showing that it's job-related and it's consistent with business necessity. Evidence shows that a test evaluates what it says it evaluates. That's really important, that the test is not designed or intended or used to discriminate on the basis of membership in a protected class. So for an eligibility test to be legally validated, it's important that it's an effective gauge of performance and important for that business necessity, and provide an appropriate analysis for those kinds of criteria and criteria-related validation, for example, like a simulated exercise, content validation, so job analysis to identify critical tasks and skills needed, construct validity tests to measure psychological characteristics. Again, needs to be job-related and well-defined in order to be appropriate. Another kind of testing that might be employed would be integrity and personality tests. Because employers have been restricted in their use of polygraph tests, many have resorted to subjective tests that purport to measure personality, honesty, integrity by analyzing, written or oral answers to certain kinds of questions. So while cognitive ability tests continue to be the most commonly used form of pre-employment testing, like what does this candidate know about this industry, or, what is their ability of this information to do the job. Personality and integrity tests are being used a little bit more frequently, but it's unclear what portion of testing they really actually account for. Some studies say that, they might be used as many as 40%, but we don't always know exactly the number that is being used. And then what's the legality of ineligibility testing? The kinds of tests that rule out someone as an inappropriate candidate. So, Addiction and substance abuse has a high cost in the workplace. It can cause productivity problems. It can relate to injuries at the workplace, high turnover rates. And so there's a lot of large companies that use drug testing on many of their jobs. And so, what's that cost benefit look like, and where is it, most appropriate to be used is something that should be. But when it comes to these kinds of testing, like drug and alcohol tests, a discharge resulting from an employee's failure to take the test for ineligibility is protected under the employment at will doctrine generally. The employment relationship is based on the consent of both parties. So if you have an employee that doesn't want to be subject to this various requirement or condition of employment, the employee gets to refuse and leave. When it comes to drug and alcohol tests, these tests are governed by both state laws and federal laws. We have the Drug-Free Workplace Act that allows screening of job applicants in response to, the continued problem of drugs and alcohol in the workplace, injuries and accidents related to their use. And then states, of course, have laws governing substance abuse testing. And so it's important for an employer to evaluate those programs to make sure they're in accordance with the laws of, both the state and federal government. Because these laws, vary widely, and so it's important for employers to make sure they're always in compliance. And then, of course, there's, 5 elements to be incorporated to be the most effective for a workplace substance abuse program. So starting with, a written drug policy that's been drafted after input from employees, a supervisory training program, number 3, an employee education and awareness program, 4, access to an employee assistance program, and 5, a drug testing program where it's appropriate. One thing that's changed in more recent years is connected to the attitudes about marijuana use. A lot of attitudes towards marijuana use have become more lenient over the last few decades, and despite recent legalization in some states and municipalities, using marijuana is still considered a criminal act under federal law, listed in the same category as cocaine, heroin, LSD, and ecstasy. Courts have upheld employers' rights to discharge employees who have positive drug tests. So it's important to note that testing for marijuana is not considered a medical test, even though several states have legalized possession and use of limited amounts of marijuana for medical purposes. The Americans with Disabilities Act of 1990 doesn't protect individuals whose marijuana use is for medical purposes. Most states have legalized medical or recreational cannabis use, leaving testing and decisions made thereafter up to individual employers' discretion. So of further interest to employers in states that do not offer employee protection component to their medical marijuana law, they may still be liable for discrimination under the ADA, even though a confirmed test for marijuana doesn't in itself qualify as a disability. Underlying medical condition for which the medical marijuana is used might actually qualify for ADA accommodations and protections. So the laws on marijuana continue to change, and it's important for employers to review substance abuse policies to ensure that their restrictions concerning the use of marijuana are consistent with restrictions permitted in whatever respective jurisdictions they're in. Employers need to review job descriptions in order to ensure appropriate categorization of safety sensitive positions, or otherwise ensure that they justify a policy against marijuana for testing purposes. What does it exist for a justifiable reason? Okay, moving on to polygraphs, which are, the lie detector test. You've probably seen these on TV maybe or something. It's a lie detecting device that measures biological reactions to an individual when they're being questioned, like in an interview kind of setting, not job interview hiring, just as an interview or as asking questions, they're reading the output of the biological reactions. It measures, breathing rates, heart activity, perspiration, and the accuracy rates vary really widely. I mean, think flipping a coin is 50%, so 50 to 90% range is a pretty big variation. And, this test is measuring these biological responses when the, examiner, that interview question person, is asking a set of questions, and the evaluation ultimately is coming out as this is an honest or this is a deceitful response. But the test has been criticized because stimulants and other than dishonesty can produce similar effects in individuals. And so there's a large number of false positives and inaccuracies in polygraph tests. A lot of people who've been wrongly accused of improper behavior. It resulted in the enactment of the Federal Employee Polygraph Protection Act of 1988. This act put an end to private employment situations for these polygraph tests. The act provides right here that employers cannot directly or indirectly require, request, suggest, or cause any employee to take or submit to a lie detector test. They can't use, accept, refer to, or inquire about the results of a lie detector test of any job applicant or current employee. They can't discharge, discipline, etc., prospective or current employees who refuse to take a lie detector test or who fail that test. There's some employer exceptions and exceptions to this that are illustrated in Exhibit 4.15 and 27 states that concur. So we've talked about lots of different kinds of testing. What about genetic testing? Genetic testing, is a scientific development that involves the use of laser and computer technology. Scientists make a diagnostic prediction by locating specific disease-associated genes on an individual's chromosome. In 2008, the federal government began regulating genetic testing in employment to prevent genetic discrimination. The Genetic Information Non-Discrimination Act of 2008, GINA, makes it illegal to discriminate against employees or job applicants on the basis of genetic information. Genetic information includes this information about an individual's gene tests and the genetic tests of their family members, as well as an individual's family medical history. In Title II of GINA, is prohibited to use genetic information in making employment decisions, restricts employers from requesting, requiring, or purchasing genetic information, and strictly limits disclosure of genetic information. An employer may access genetic information under very few limited exceptions, but they're never allowed to use genetic information to make an employment decision because genetic information is not seen as relevant to an individual's current ability to work. In addition to GINA, other states have provided additional protection for genetic testing. And one of the issues raised by genetic testing is that genetic irregularities that substantially impair a major life activity may be considered protected disabilities under the Americans with Disabilities Act and the Vocational Rehabilitation Act. A genetic test may encourage discrimination based on myths, fears, and stereotypes about genetic testing, which is prohibited under the ADA. So employees or job applicants are protected from discrimination based on their HIV or AIDS status. The ADA, the Americans with Disabilities Act, and the Vocational Rehab Act is the federal law that protects these employees or job applicants. During the interview process, the ADA limits employers with regard to questions they can ask surrounding an individual's medical condition or HIV status and prohibits pre-employment medical exams. Specifically regarding HIV, an employer can only ask it about employee status or conduct related to the exam if their position with a positive HIV status would pose a direct threat to the health and safety in the workplace, or knowledge of that status is vital for the workplace. The inquiry is conducted, post-offer, and the same inquiry test is made of all employees in the same job category that are asked to submit to the same kind of medical exam. It's important to note that an EEOC regulation might use a phlebotomist as an example of not meeting the direct threat standard for exclusion from consideration. And a phlebotomist is like a person who draws blood flaps. So management considerations for testing. So 3 possible approaches for testing an employee for ineligibility. There's kind of 3 approaches that managers can take for this kind of testing. They could have mandatory testing, so testing for drug or alcohol use or some other form of ineligibility, mandatory. They could implement probable cause testing, so an employer tests employees only if there's a suspicion, or some employers may implement random testing, so random individuals are picked for testing on a periodic basis. It's important to make this decision strategically, considering cost and benefit, corporate culture, local laws, that may apply. But the policy needs to be clear, clearly written, clearly articulated, clearly communicated, and applied evenly in order to not be in violation. So let's look at performance appraisals, evaluation, and discipline systems. Generally, employees want to enter organizations and rise as high as they can go. Employees want to succeed in their work, and they're going to do that by meeting their employer's expectations in an exemplary way. Success is usually documented by both sides throughout performance appraisals, but disputes can arise when an employer's expectation of an employee are not aligned with the employee's understanding of the performance expected or offered. They're most often brought to light through the evaluation system. The purpose of these appraisals should be identifying those characteristics the employer hopes the employee will accentuate and to dissuade the employee from exhibiting characteristics in not keeping with the organization's objectives. Performance appraisals have the potential for discriminatory effect because discrimination may exist in the way the employer utilizes the evaluations as well as the manner that the appraisal is conducted. So there's some realities to consider about these performance evaluations. An employer could be liable for giving a negative reference even if it's based on valid performance appraisals. Be really careful when it comes to references. We've kind of already talked about that a little bit. Employers shouldn't need to lower the standard or qualifications to accommodate, an employee's needs or applicants. That's not what accommodations mean. It doesn't mean lower the standard. It means provide tools to meet that standard where it's appropriate and reasonable. Performance appraisal systems should maximize reliance on objective measures so that we know that we're applying these to all the employees, similarly situated and appropriately. Incentive systems, recognizing outstanding performance and leadership, those are performance incentive systems, and those are important to recognize and to provide those incentives to encourage good performance and great leadership. But there's legal challenges found in some of these areas as these things are being implemented. There could be problems with how they're monitored over time and accountability based on these appraisals. So the legal implications of a performance appraisal become relevant when their information is used as the basis for an employment-related decision. Improper performance appraisal systems are those that don't fairly or adequately evaluate performance, but instead perpetuate stereotypes that have an adverse impact on protected classes. Disparate impact may be determined by a number of methods, but of course one of the most common methods we've already talked about is that 4/5 rule. The 4/5 rule holds that there's a presumption of discrimination where the selection rate for this, whatever the employment decision was, of the protected group is less than 80% the selection rate of the non-protected group. Of course, just as with other areas where disparate impact is alleged, the employer can defend the system used as long as the performance appraisal was sufficiently job-related. There's got to be some reasonable need for it, some means by which to ensure the system's objectivity and fairness. And then disparate treatment. A performance appraisal may also result in disparate treatment, such as where a female employee is evaluated according to different criteria than the male employee. While most of the people would claim they rate people based on equivalent factors, research has shown that sometimes they do not. In fact, raters are often influenced by physical or other traits or attributes that they shouldn't be influenced by. An employee disputing the performance appraisal may also prove a case using the disparate treatment analysis, as it's articulated in the case of McDonnell Douglas in that framework. The employee can show that he or she first is a member of a protected class, they suffered an adverse employment decision as a result of the performance evaluation, they were actually qualified to perform the responsibilities of the position, and they were replaced by someone with similar qualifications who is not a member of the protected class. And then it's also important to remember under the ADA to prevent against defamation, these performance evaluation considerations should still have the same standard. We're not talking about lowering the standard, but making appropriate accommodations and making sure that these cover essential functions of the job. So let's talk about discipline. Just as any other area that involves actions directed towards employees, employee discipline is a sensitive area, one that must be approached with a critical eye. If an employer can show that its discipline of an employee was for just cause, it may more effectively be prepared to defend itself against EEO laws. Ensuring that a just cause disciplinary approach, wherever possible, may serve to create a reputation for the employer that in turn will act as a positive inducement for prospective employees. In general, just cause in discipline or discharge is determined by exploring three elements. First, they're going to consider the employee has received due process. Then whether there is adequate evidence of whatever charge has been made against the employee. And then third, whether the penalty chosen is appropriate. Documentation, so important. The most effective and efficient method, to make sure all these things is to completely document every action taken, whether the action was written or oral, and its background support. This assures employees of adequate feedback, and lawsuits won't hinge on vagueness of a particular supervisor's memory after the fact. Progressive discipline involves sets of steps before a challenging employee will be terminated for poor performance. These steps can begin with like an oral warning, followed by a written warning or light punishment, and so on, until reaching that determination. It's important that failure to impose this progressive discipline system is a standard format for all covered workers that might result in potential liability for desperate treatment. So again, it's important to make sure that these steps are followed and follow policy and documented the situation that is the cause for whatever the policy steps are taking place. This exhibit for discipline is the 7 tests of just cause. This useful measurement of just cause comes from arbitrator Carol Dougherty in Grief Bros, and it is now commonly just referred to as the 7 tests of just cause. And an employee who's subject to discipline has a right to request a coworker be present as a witness during an investigatory interview. Documentation of discipline, as well as of appraisals, warnings, commendations should be retained in employees' files and should be given to the employee prior to provide him or her with the opportunity to appeal the action. So these are the 7 tests. Did the employer give the employee forewarning of this disciplinary consequence? Is that rule or managerial order reasonably related to the orderly, efficient, or safe operation of the business? Did the employer, before issuing discipline, make an effort to discover whether the employee violated or disobeyed a rule or order of management? Was the employer's investigation conducted fairly and objectively? At the investigation, did the employer obtain substantial evidence or proof the employee was guilty as charged? Has the employer applied its rules, orders, and penalties even-handedly and without discrimination? And lastly, was the degree of discipline administered by the employer reasonably given A, the seriousness of the employer's proven offense, and B, the record of the employee's service? So some management tips to finish off this chapter. It's important to maintain appropriate documentation of performance appraisals, train supervisors, train leaders on non-biased reporting and evaluation practices, take precautions against inappropriate disclosures that could lead to liability, and evaluate performance frequently, systematically, and as stated in the employee manual and other materials. And that's the end of chapter 4. Please let me know if you have any questions about this material. You can send me an email or come visit office hours.